The Supreme Court just delivered a devastating blow to Donald Trump's entire legal strategy. In a terse 4-page order released at 3:47 p.m. Eastern Time this afternoon, all 9 justices unanimously rejected Trump's emergency request to delay proceedings in the classified documents case, a decision that legal experts are calling the most consequential judicial rebuke of a former president in modern American history. And this isn't just another routine denial or procedural setback. This represents the complete collapse of Trump's final firewall against prosecution, triggering what sources inside Mar-a-Lago describe as absolute pandemonium as Trump's legal team fractures in real time, with 3 top attorneys reportedly resigning within hours of the ruling. When the Supreme Court unanimously denies an emergency stay request from a former president facing espionage charges, using language that constitutional scholars describe as unusually pointed, you know the legal foundation protecting Trump just disintegrated. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what triggered this unprecedented Supreme Court rejection? According to the order itself, which I've reviewed in full, the justices determined that Trump's legal team failed to demonstrate any basis for delaying trial proceedings scheduled to begin March 4th in the Southern District of Florida. But what makes this truly explosive is the language the court used. In a footnote that legal analysts are calling extraordinarily rare, the order states that applicants' counsel has not identified any substantial question that would warrant this court's intervention at this stage. That phrasing, according to former Supreme Court clerks, represents judicial code for your arguments are so weak they don't deserve serious consideration. This wasn't a close decision where conservative justices sided with Trump while liberals dissented. All 9 justices, including the 3 Trump appointed himself, agreed his emergency request lacked merit. Constitutional scholars are calling this the most unified judicial rejection of presidential immunity claims since United States v. Nixon. And believe me, when justices appointed by the president they're ruling against join a unanimous decision calling his legal arguments insufficient, something catastrophic has destroyed any remaining judicial sympathy for his position. Here's the full picture of what's been unfolding. Trump's legal troubles intensified dramatically on February 1st when Judge Eileen Cannon, who had previously shown considerable deference to Trump's defense motions, issued a 47-page order denying yet another attempt to dismiss the classified documents case. But everything exploded yesterday when Trump's attorneys filed an emergency application with the Supreme Court asking for an immediate stay of all proceedings, claiming that continued prosecution violated presidential immunity principles and would cause irreparable harm to the office of the presidency. The application, filed by attorney Christopher Casey at 2:18 p.m. yesterday, requested that the court halt the trial set to begin in just 27 days. According to court filings, Trump's team argued that forcing a former president to stand trial on criminal charges while he's actively campaigning for re-election creates constitutional problems that require the highest court's immediate intervention. The Supreme Court's response came with shocking speed. Normally, emergency applications receive responses within several days as justices review briefs and consider arguments. This decision came in under 26 hours, suggesting the justices found Trump's claims so lacking in legal merit that extended deliberation wasn't necessary. According to former federal prosecutor Joyce Vance, who spent 25 years in the Justice Department, when the Supreme Court moves this quickly on an emergency stay request, it's sending an unmistakable message that the application was frivolous. She told MSNBC this evening that the speed of this rejection, combined with the unanimous vote, tells you everything about how weak Trump's legal position has become. The court didn't even request a response from special counsel Jack Smith's office before denying the application, a procedural detail that former Supreme Court litigators say demonstrates the justices viewed Trump's arguments as facially insufficient. That means the claims were so weak on their face that the court didn't need to hear counter-arguments before rejecting them. Smash that like button if this is making sense so far. Here's where it really gets serious. Within 90 minutes of the Supreme Court order being published, extraordinary chaos erupted inside Trump's legal team. According to sources who spoke with CNN and the New York Times, 3 attorneys working on Trump's defense, James Trusty, John Rowley, and Lindsay Halligan, submitted resignation letters citing irreconcilable differences over legal strategy. The resignations weren't quiet departures or future-dated transitions. These were immediate, effective, immediately resignations submitted while Trump was meeting with remaining attorneys at Mar-a-Lago. Sources familiar with the meeting, who spoke on condition of anonymity because of the sensitivity of internal deliberations, described the scene as absolute chaos. Trump was reportedly on speakerphone with Christopher Kise, his lead attorney in the case, when news of the Supreme Court ruling broke. According to one source who recounted the conversation to reporters, Trump's immediate reaction was disbelief, followed by anger directed at his legal team for what he characterized as incompetent representation. But here's what sources say happened next that reveals the true desperation of Trump's situation. Trump allegedly told attorneys present, according to two sources familiar with the conversation, that they needed to find new arguments, new motions, anything to delay the trial. When attorneys explained that the Supreme Court's ruling effectively closed off remaining delay tactics, Trump reportedly responded by saying, his voice rising according to witnesses, "Then we change lawyers. We find people who know how to win." That statement triggered the immediate resignations, according to sources, because attorneys recognized they were being positioned as scapegoats for legal losses that resulted from weak underlying claims rather than attorney performance. One departing attorney told a colleague, according to sources, "I'm not going to be blamed for the inevitable when the problem isn't the lawyers, it's the evidence." The tension in the room reportedly escalated further when Trump began discussing potential replacement attorneys, mentioning names of lawyers that current counsel viewed as unqualified for federal criminal defense at this level. According to one source present, there was a fundamental disconnect between Trump's desire for attorneys who would pursue aggressive delay tactics regardless of legal merit and the professional judgment of experienced counsel who understood those tactics would fail and potentially result in sanctions. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely explosive. The Supreme Court's rejection creates immediate and cascading consequences for Trump's legal defense that go far beyond this single case. First, the ruling eliminates Trump's ability to delay the classified documents trial, meaning jury selection begins March 4th as scheduled. That puts Trump in a federal courtroom facing 37 felony counts, including willful retention of national defense information and obstruction of justice during the peak of primary season. According to the trial schedule approved by Judge Cannon, the proceedings are expected to last between 6 and 8 weeks, meaning Trump could be sitting in a courtroom rather than campaigning through most of March and into April. The political ramifications are staggering. Trump will miss critical campaign events in Super Tuesday states. He'll be unable to attend fundraisers that his campaign desperately needs to compete financially with a well-funded Democratic incumbent. And perhaps most damaging, he'll be physically present in a federal courthouse while prosecutors systematically present evidence of alleged criminal conduct to a jury and the watching nation. Second, and this is critical, the Supreme Court's reasoning creates binding precedent that will affect Trump's other pending criminal cases. According to constitutional law professor Lawrence Tribe of Harvard Law School, who has argued dozens of cases before the Supreme Court, this ruling effectively forecloses the presidential immunity defense across all of Trump's prosecutions. When the Supreme Court unanimously says immunity claims don't warrant intervention, that guides every lower court handling Trump's other cases. The ruling will be cited by prosecutors in the January 6th case in Washington, D.C., the election interference case in Georgia, and the Manhattan criminal case involving hush money payments. Defense attorneys in those cases will find it nearly impossible to argue for delays based on immunity when the Supreme Court has already rejected such arguments unanimously in the most serious case Trump faces. Here's the absolute kicker. The third consequence involves Trump's ability to maintain a functioning legal defense. With 3 attorneys resigning immediately after the Supreme Court ruling, Trump now faces a trial beginning in 27 days with a depleted legal team that must integrate new counsel while preparing for the most complex and high-stakes criminal proceeding in modern presidential history. According to former federal public defender David Patton, who now teaches at Yale Law School, bringing new attorneys onto a major federal case with less than a month before trial is a nightmare scenario. New counsel needs to review thousands of pages of discovery, develop familiarity with hundreds of classified documents, prepare cross-examination strategies for dozens of potential witnesses, and coordinate with co-defendants, all while dealing with a client who, according to multiple reports, frequently rejects legal advice in favor of political strategy. The logistical challenges alone are overwhelming. New attorneys must obtain security clearances to review classified materials, a process that typically takes weeks or months. They must establish working relationships with Trump's co-defendants and their attorneys, including Walt Nauta and Carlos de Oliveira, whose cooperation or lack thereof will significantly impact trial strategy. And they must do all this while managing a client who, sources say, views legal proceedings primarily through a political lens rather than following traditional attorney-client dynamics. Don't go anywhere. The most explosive part is coming next. And here's what should alarm everyone, regardless of political affiliation. This isn't just about Trump or this specific case. The Supreme Court's ruling establishes that former presidents cannot use immunity claims to avoid accountability for criminal conduct. That's a fundamental question about whether anyone can be above the law. Once that precedent is established clearly and unanimously by the highest court in the land, future presidents of either party will understand they face genuine criminal liability for illegal conduct. The implications for executive accountability are profound. For 248 years, the question of whether former presidents could face criminal prosecution remained largely theoretical. Presidents left office and returned to private life without facing criminal charges, not necessarily because they were immune, but because prosecutors declined to pursue cases against former chief executives. That norm has now been shattered. The Justice Department under Attorney General Merrick Garland made the decision to prosecute a former president, and now the Supreme Court has validated that decision by refusing to intervene based on immunity claims. This creates a new reality for anyone who serves as president. The office no longer provides protection from criminal accountability after leaving power. This puts Trump in an absolutely impossible legal position. On one side, he faces a trial beginning March 4th with evidence that prosecutors describe as overwhelming, including security camera footage showing boxes of classified documents being moved, testimony from more than a dozen witnesses, including Trump's own attorneys, and audio recordings where Trump allegedly discusses classified materials he acknowledges he cannot declassify. That evidence, according to the 49-page indictment, demonstrates willful and systematic violations of laws protecting national defense information. Prosecutors allege Trump stored classified documents in a ballroom, a bathroom, a bedroom, and a storage room at Mar-a-Lago. They have photographs showing boxes stacked in a shower. They have testimony from staff members who moved boxes at Trump's direction. They have messages between Trump and his attorneys discussing how to avoid complying with a federal subpoena for the documents. On the other side, he confronts a depleted and fracturing legal team that has just lost 3 experienced attorneys while facing the most serious criminal jeopardy of his life. And here's the impossible bind that legal experts say Trump now faces. If Trump continues seeking delays through additional motions and appeals, he risks appearing to Judge Cannon and eventually to a jury as someone avoiding accountability, which prosecutors will characterize as consciousness of guilt. The Supreme Court's ruling makes clear that further delay attempts will be viewed skeptically by courts. Every additional motion to postpone, every new argument for continuance will be seen through the lens of this unanimous Supreme Court rejection. Judges will question whether Trump is genuinely raising legitimate legal issues or simply attempting to run out the clock until after the election. If Trump accepts the March 4th trial date and proceeds with his current diminished legal team, he enters the courtroom at a significant disadvantage against federal prosecutors who have been preparing this case for 18 months with unlimited resources. According to former prosecutors, trying to integrate new attorneys at this stage creates visible disorganization that juries notice and interpret negatively. Jurors expect professional, coordinated defense presentations. When they see attorneys who appear unfamiliar with evidence, who object inconsistently, who seem to be learning the case in real time, it undermines confidence in the defense and, by extension, in the defendant's claims of innocence. If Trump attempts to negotiate a plea agreement to avoid trial, he faces the political catastrophe of admitting criminal conduct while actively campaigning for president, destroying his central narrative that all prosecutions are politically motivated witch hunts. A plea deal would require Trump to allocate to facts, meaning he would need to admit in open court that he committed the crimes charged. That admission would be used against him relentlessly by political opponents and would fundamentally undermine his claims that he's a victim of political persecution. There's no legal strategy that addresses all 3 problems simultaneously. Constitutional scholars and former prosecutors are calling this one of the most legally perilous moments any former president has ever faced. Andrew Weissman, who served as lead prosecutor in the Mueller investigation, stated on MSNBC tonight that Trump is now in uncharted legal territory. We've never seen a former president facing a criminal trial on this timeline with evidence this strong and a legal team this fractured. Barbara McQuaid, former U.S. attorney for the Eastern District of Michigan, wrote in an Atlantic essay published this evening that the Supreme Court's unanimous rejection represents more than just a procedural loss. She wrote, "This ruling signals that the judiciary, even justices appointed by Trump himself, will not enable delay tactics that undermine the rule of law. It's a remarkable moment of institutional integrity. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even Republicans who have consistently defended Trump acknowledge the gravity of his legal situation." Former Attorney General Alberto Gonzales, who served under President George W. Bush, told CNN that while I've been sympathetic to arguments about presidential immunity in certain contexts, the Supreme Court's unanimous ruling suggests Trump's legal theories have been rejected at the highest level. At some point, the legal process has to move forward. William Barr, who served as Trump's own Attorney General, wrote in a Wall Street Journal op-ed published late this afternoon that the Supreme Court's decision, while predictable to anyone familiar with constitutional law, should prompt serious reflection about the strength of the underlying legal position. Barr, who has defended Trump on numerous occasions and who wrote a memo before becoming Attorney General arguing that presidents cannot obstruct justice, stopped short of defending Trump's conduct in the classified documents case, noting that the allegations involve post-presidency conduct that falls outside executive authority. So let's break down exactly what this means going forward. First, immediate trial preparation crisis. Trump's legal team must now prepare for trial beginning in 27 days while dealing with the departure of 3 attorneys and attempting to recruit replacements willing to take on what multiple legal experts have described as an extremely difficult case. According to sources familiar with Trump's legal recruitment efforts, several prominent defense attorneys have declined to join the team, citing concerns about Trump's willingness to follow legal advice and the challenges of the case itself. That limits Trump's options precisely when he needs the strongest possible representation. The pool of attorneys qualified to handle a classified documents case at the federal level is relatively small. These cases require specialized knowledge of the Classified Information Procedures Act, familiarity with handling sensitive compartmented information, and experience navigating the complex intersection of national security law and criminal procedure. Many of the nation's top national security defense attorneys have already declined to represent Trump, either because of conflicts, concerns about payment, or unwillingness to be associated with the case. Second, the evidentiary picture becomes undeniable. With delays eliminated, prosecutors will present their case starting March 4th. That case, according to the indictment, includes security footage from Mar-a-Lago showing Walt Nauta, Trump's aide, moving boxes of documents at Trump's direction. It includes testimony from Trump's own attorney, Evan Corcoran, whose notes were compelled through a crime fraud exception to attorney-client privilege. It includes an audio recording from a July 2021 meeting where Trump allegedly discusses a classified document about potential attacks on Iran, stating, "As a president, I could have declassified it. Now I can't." That evidence, presented in open court with live witnesses subject to cross-examination, will dominate news coverage for weeks. Television networks will provide gavel-to-gavel coverage. Legal analysts will dissect each day's testimony. And the cumulative effect of weeks of damaging evidence being presented in a formal judicial setting will be politically devastating regardless of the eventual verdict. Finally, the political implications create an impossible situation for Trump's campaign. Trump will be sitting in a federal courtroom during critical primary season, unable to campaign in key states, while news coverage focuses relentlessly on evidence of classified document mishandling. According to political strategists from both parties, there's no historical precedent for how voters respond to a candidate actively on trial for espionage-related charges while running for president. Early polling suggests significant vulnerability. A recent NBC News poll found that 54% of registered voters, including 22% of Republicans, said they would be less likely to support Trump if he were convicted of mishandling classified documents. That creates enormous pressure on Trump's campaign to somehow neutralize the trial's political impact while Trump himself is physically unable to campaign. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond immediate legal and political fallout, this represents a test of whether the American legal system can hold powerful figures accountable regardless of their political status. The founders created a system where no one, not even presidents, could escape consequences for criminal conduct. If that system works, Trump faces trial on schedule, a jury evaluates evidence, and a verdict follows based on facts and law. If partisan divisions prevent accountability despite overwhelming evidence, it demonstrates that political power can overcome legal process. This situation is causing absolute pandemonium, not just within Trump's legal team, but throughout the Republican establishment. Reports from Capitol Hill indicate that Republican leadership has been fielding calls from major donors expressing concern about Trump's legal vulnerabilities affecting down-ballot races. According to Politico, which spoke with 3 major Republican donors on condition of anonymity, there's growing anxiety that Trump's legal problems will dominate the news cycle through the summer, making it impossible for Republican candidates to focus on policy issues. One major donor told Politico that we're facing a scenario where every Republican candidate in every competitive race will be asked whether they support a convicted felon for president. That's not a winning message. Meanwhile, prosecutors at the Department of Justice are preparing for trial with what sources describe as meticulous attention to detail. According to CNN, which spoke with sources familiar with trial preparations, special counsel Jack Smith's team has been conducting practice witness examinations, refining opening statements, and preparing demonstrative exhibits designed to make complex classified documents laws understandable to jurors. The prosecution team, which includes some of the most experienced national security prosecutors in the country, has been preparing for this trial for over a year. They've interviewed more than 80 witnesses. They've reviewed thousands of hours of security footage. They've analyzed financial records, communications, and physical evidence. This is not a rush job or a politically motivated prosecution cobbled together hastily. This is a comprehensive, methodically built case supported by the type of evidence that typically results in convictions. Stay with me because what comes next will completely change your understanding of where this leads. Here's what makes Trump's strategic response so legally dangerous and self-defeating. In a Truth Social post published at 5:23 p.m., just 96 minutes after the Supreme Court ruling, Trump attacked the justices in terms that legal experts immediately identified as problematic. Trump wrote, "Even the Supreme Court has been infected by the radical left. They refuse to see the election interference happening right before their eyes. This is a violation of my rights like nothing ever seen before." But legal analysts noted that attacking the Supreme Court, particularly after a unanimous ruling that included justices he appointed, accomplishes nothing legally while potentially alienating the very institution he might need in future appeals. Former federal prosecutor Renato Mariotti tweeted that Trump attacking a unanimous Supreme Court decision, including his own appointees, demonstrates he's receiving terrible advice or ignoring good advice. Neither option bodes well for his legal future. Conservative legal scholar Jonathan Turley wrote in a blog post that while Trump has legitimate grievances about the timing and political context of his prosecutions, attacking the Supreme Court after a unanimous ruling suggests a fundamental misunderstanding of how to preserve appellate options. If Trump is eventually convicted and appeals, he will need the Supreme Court to consider his arguments favorably. Attacking the court publicly makes it more difficult for justices to rule in his favor without appearing to reward intimidation or yield to political pressure. This goes far beyond one Supreme Court ruling or one criminal trial. It's about whether the United States maintains a legal system capable of holding former presidents accountable when evidence suggests serious criminal conduct. If Trump can indefinitely delay accountability through procedural motions despite overwhelming evidence, then future presidents understand they can violate laws with impunity as long as they maintain political support. That's not just dangerous for democracy. It's a complete breakdown of the constitutional order. If this blows your mind, hit that like button right now. Here's where everything stands at this moment. The Supreme Court unanimously rejected Trump's emergency request to delay his classified documents trial, using language that legal experts describe as a definitive rejection of immunity claims. Trump's legal team fractured within hours, with 3 attorneys resigning immediately. Trial proceeds is scheduled on March 4th, just 27 days away, and Trump faces the most serious criminal jeopardy of his life with a depleted defense team, rejected legal theories, and evidence that prosecutors describe as ironclad. This isn't political theater or partisan warfare. This is the closest America has come to trying a former president for espionage-related conduct in the nation's history. When the Supreme Court unanimously rejects delay tactics, when a former president's own attorneys resign rather than continue defending increasingly untenable positions, when evidence includes security footage, witness testimony from Trump's own lawyer, and audio recordings of Trump discussing classified materials, the legal system is being tested in ways that will define presidential accountability for generations. Keep an extremely close eye on this story because the trial beginning March 4th will determine not just Trump's personal fate, but fundamental questions about whether presidents can be held criminally accountable for conduct after leaving office. Jury selection begins in 27 days in Fort Pierce, Florida, with Judge Eileen Cannon presiding. Prosecutors will present evidence over approximately 4 weeks, including live testimony from FBI agents, Trump attorneys, Mar-a-Lago staff members, and national security officials. Trump's defense team, whoever ultimately comprises it, will present their case, though legal experts note the extraordinary challenges of defending against photographic evidence, witness testimony, and audio recordings. And at the end of what could be a 2-month trial, 12 jurors will render a verdict on whether a former president of the United States willfully violated laws protecting classified national defense information. Before we go any further, smash that subscribe button so you never miss content like this, because this legal crisis is unfolding in real time and represents the most serious criminal jeopardy any former president has ever faced. The Supreme Court has spoken unanimously. The trial date is set. Trump's legal team is fracturing, and in 27 days, the American legal system will attempt something it has never done before: hold a former president criminally accountable for conduct that prosecutors allege threatened national security. The stakes have never been higher for presidential accountability. The evidence has never been more concrete, and the legal crisis has never been more immediate. Pause for a second and hit that like button if you're finding value in this coverage.